We're back to the ABCs of environmental law. When people think about environmental law, or really any kind of law, they're really thinking about judges and courtrooms, the stuff you see on TV. But in reality, most environmental law lives outside the courtroom because it's something entirely different. It's administrative. Administrative law is the law of agencies. It's how agencies like EPA, DTSC, the water boards, fish and wildlife, building and planning departments, county health departments, air districts make their rules, issue permits and licenses, investigate problems, and enforce environmental laws. And here is the key thing to understand. Most environmental cases never start in court. They start with an agency making policy. The agency has the ability to enforce those policies, and that's usually not a lawsuit. It could be a letter, a notice of violation, a cleanup order, or a permit condition. And administrative law governs how those agencies are allowed to act, what procedures they have to follow, what evidence they can rely on, and what rights you have to respond, challenge, negotiate, or appeal. And this is where things can get tricky. Unlike court cases, we often don't have clear, predictable guidance or case law telling us exactly how an agency will handle one situation versus another. Agencies have broad discretion, and that discretion can feel overwhelming and sometimes unfair. It's also tricky because the rules are different. Deadlines, paperwork, and standards of review don't work the same way in administrative law as they do in court. So if you miss a deadline or if you ignore an agency request, you could lose important rights without ever having the opportunity to see a judge. So these cases can feel informal, but the consequences are very real. Agencies impose penalties, require investigations or cleanup, and they can determine what you could do with a property or a business on a go-forward basis. You could really be limited in the future. So understanding administrative law means you are understanding the rules of engagement. And in environmental law, knowing how to work within that system can make the difference between a manageable problem or a very expensive one.